7 p.m. And this is the regularly scheduled Town of Ridgefield Inland Wetlands Board meeting for Thursday, September 28th, 2023. And in attendance, we have Carson Fincham, Tim Bishop, Alan Pilch, David Smith, Chris Phelps, myself, Susan Baker, Caleb Johnson, Arti Paranjape from staff, and attorney Tom Beecher. We'll move on to item 2, which is IW-23-1827 Abbott Avenue plenary ruling application for construction of apartment complex, associated parking and drainage infrastructure within the upland review of wetlands. And, okay, so as a reminder, the public hearing closed at our last meeting, and so the only things that can be considered in our discussion are things that are entered into the record. And the dates, we need to make a decision per statute in 35 days. That would mean we'd have to have it done by October 19. We have a meeting on the 12th. We could also ask the applicant, if necessary, to extend us to October 26th, but that would be the last date we could finish this up, just so you know. And Attorney Beecher has joined us, and I had asked him if he could please review for us and for all the attendees the regulations that we need to be considering here, which are in our book 10.2, 10.3, and 10.6. And also, this application does have an intervener, so there are some issues there that we need to refresh our memories on. So thank you, Tom, if you would like to go ahead.
Sure, thank you. I went through some of this 2 meetings ago when I was here on a different application, although I also listened to this one, that same meeting. Generally speaking, for an approval or an approval with conditions or a denial, the reasons for any of those need to be based on very real evidence and testimony in the record. And whichever direction you go in, your reasons must be stated in your motion or your resolution of approval. Another major point is that for this application, you also need to address the issue of feasible and prudent alternatives. And lastly is the issue of intervention that Susan just mentioned. With respect to a denial, if you're going to deny an application, you must look at real substantial evidence in the record for that denial that establishes that the activities will in fact have an impact on a wetland or a water course. And you have to articulate what those are. And you also have to articulate what the feasible and prudent alternative is to the project as ultimately and finally designed before you close the public hearing. If a feasible and prudent alternative exists, the statute says you must point that out and identify it in your motion or your resolution of denial to give the applicant some idea of what the alternatives are for them to explore. Now, with respect to your decision considerations, those are spelled out in sections 10.2, 10.3, to some extent 4 and 5, but also in section 10.6. And those are all, they all mirror the statutory requirements for what you look at when deciding the application. One thing I wanted to touch on, because I did see that it came up when I was here the last time, is that there was a discussion of salamanders and how the salamanders might have difficulty transitioning from the wetland into this property because of a retaining wall. It's fine for you to consider that, but in terms of being a reason for a condition or a reason for denial, you have to have some evidence in the record preferably expert testimony in the record that any disruption of the amphibians, whether it's frogs or salamanders, will have a likely impact on a wetland. It's not enough that their pathway through this particular property, or perhaps they hang out on this property, is disrupted. There has to be some nexus. In other words, whatever that disruption might be has to actually impact the wetland itself. So keep that in mind if you're considering that. And then with respect to the intervention, and in your discussion tonight, it really depends on what direction the board ultimately wants to go in terms of what your consensus is, because based on that, then the intervention can also be dealt with simultaneously at that particular time. But, you know, the intervention was granted in terms of participation, and at this stage, you have to make certain findings, but the feasible and prudent alternative comes into play with an intervention the same way it's going to come into play here anyway. So when we get to that point, we can then address the intervention as well. So I think preliminarily that covers what I thought might be a good idea to cover.
Okay, so we don't need to do anything about the intervention prior to taking it up in general. We can all be, okay, that's part I didn't understand from reading that document that you had given us some time ago. Okay, so
let me just clarify. I'm sorry, Susan.
yeah.
I mean, at this point, you're at the discussion stage. So I at least don't know what direction the board might be going. So, you know, once everyone's discussed it and gone through their feelings and where things might go, then we can address what we need to do with the interveners.
Okay. Fine, then we'll open it up to discussion. Carson, you have your hand up.
Thank you. And thanks, Tom. That was a good intro. It's just one preliminary question I had with respect to the intervention and the regular section, 10.2 and the analysis. It looked to me from reading the documents having to do with the intervention and going back and pouring through section 10.2 that there may be, and this may not come into play depending on the decision, but I'm just curious, because it may, depending on how it comes out. It sounded to me like they used different language in the intervention with respect to the impacts on the wetland, right? So you had, in order to find that the intervention, I don't know what the proper terminology is, was successful or meaningful, you have to find that there was, I think it was an impact on the wetland that was unreasonable as opposed to a reasonable impact on the wetland, whereas 10.2 doesn't use that language. So I'm wondering if there's any distinction that you're aware of between how that might play out.
Well, sort of the Reader's Digest version of the two parts to this phase of intervention is you make a determination as to whether it's reasonably likely that some natural resource, such as a wetland, would be impacted by this project as it's designed. If you answer that question yes, then you have to make a decision as to whether that impact is unreasonable. And if it's unreasonable, then the intervener has proven their case, and you have to make a determination that there's no other feasible and prudent alternative in order to get through that hurdle. So it's similar, but yes, you're correct. The language is slightly different in the intervention statute than what the case law and your regulations state, which is in order to deny an application, you have to really find that there's an actual harm that will happen to a wetland.
Whether that harm is reasonable or unreasonable, which is more of the intervention standard.
Correct.
Okay. Thank you.
Chris?
Yeah, hi, Tom. I have a question, and I don't think it's relevant to anything that we're talking about now, but during the discussion of the applicant, they continually cited the fact that Ballard Green was established and built within a very narrow, right near the wetland. And their argument was that because it was done in the past, we can do it now. And it seems, or at least that's the way I heard it. It seems to me that there's a higher standard because we have better knowledge about the impact on nature and things like that. Is there a way we can? Is there a way I can refute that? And
Well, it's very easy. You don't have to refute anything. Their application is bound by what your current regulations and current state statutes are. So the fact that Ballard Green was built at a different time or under different circumstances or what have you is of no moment. It's not relevant to what you're reviewing in this application. You know, the report that I saw from the Southwest Conservation District talked about the sins of other properties and those sins impacting this wetland. And the Conservation District was saying, you know, this applicant has done some things that will actually help to mitigate the sins of other properties. And that's okay. But you don't have to look at this application and say, oh, well, if Ballard Green got away with it, then we have to let this applicant get away with it. No. That's not how it works.
okay, thank you.
I have a further question, Tom, also.
Yep.
In terms of, we have now 100-foot upland review area, but there's nothing, is there, in the regulations that state definitively how much of a buffer you absolutely must have between the wetland and development?
Well, correct, because an upland review area is just that. It's an area that's up from a water course or a wetland that you have jurisdiction to review the activity either in that URA or activity that could be even further away than 100 feet that might impact a wetland. It's not a no-build zone. It's just a review area where you can look at that and then make a determination as to whether, you know, there's going to be an impact on a wetland. I mean, we've seen an application where you have severe slopes, so obviously that 100 feet is very important, but it's not a no-build zone. You know, it's not the buffer, and there's many articles on this in the state of Connecticut. The term buffer really should be avoided because that's not what it is. It's not a buffer where nothing can happen in that 100 feet.
Okay. Anyone else? At this point, Alan?
Yeah, Tom, perhaps I can ask this question too. Similarly, the applicant on this project, I believe, brought up the project that this board had reviewed at 100 Danbury Road. You know, it's Danbury Road at right near Leegy's Way. And there, I mean, they said that, you know, we had approved, you know, impervious surfaces within close proximity of wetlands. To me, I mean, I always think that we review things on a case-by-case basis because every situation is different. And, you know, on that project, for example, there was a lot of planted mitigation that was provided. So the situation is very different. So even though we might have, you know, approved an application on a site which had impacts, zero use, within the upland review area, I don't think, I guess what I'm asking is, because we might have approved it on a different project, we're not bound necessarily by those decisions, I presume. And, you know, that we have to look at everything on a case-by-case basis because every wetland is different. You know, and the way it interconnects with the environment surrounding it. So that's really what I was
That
question here too.
And you're correct. Every application and every site is different. It could be the quality of the wetlands that you're seeking to protect. It might be different than the one where you allowed something that you might not otherwise. The mitigation, as you mentioned, is also something that separates applications, perhaps, including also the construction of new wetlands to replace what might be being built. So yes, every application is different and should be looked at on its own merits. However, if everything else is equal, then certainly you don't want to be accused of unequal treatment between applicants. But the primary thrust of your comments are absolutely correct.
Thank you.
Anyone else want to actually dig into the actual discussion then? We have 2 peer reviewers. We can also consider other reviewers, the interveners reviewers.
I guess I have one more question for Tom, actually.
Okay, we should get them all out.
Okay, so one question that was posed by the applicant to Mr. Verbicas is he sort of toward the end of the application discussion, he said, does the design satisfy the regulation or satisfy the requirement? And Mr. Verbicas was very careful to say it satisfies the requirement of the wetland code. And so my interpretation of that is stormwater management is actually regulated by P&Z. So we don't have a specific stormwater management requirement in our code. It's really up to the individual wetland managers to determine if they think the project could harm the wetlands, whether it's because of stormwater runoff or something else. So I guess what I'm saying is I'm not sure by saying it satisfies our code that necessarily speaks to the merit of the project, since we do not outline a specific stormwater management requirement. It's more for us to take in the entire application and decide whether or not it could harm the wetland. Is that correct?
Well, let me see if I can answer the question, because I'm not sure of all the parts of your question.
Okay.
If your peer review engineer says that it complies with the stormwater management regulations under zoning, that's certainly evidence that the stormwater management facilities are functioning at some high level.
But he did not say that. He was very careful in his word choice. He said it met the requirements of the wetlands code, but we don't have specific stormwater management requirements in our code. On that point, I guess that's true. And that would mean that any stormwater management application that comes before this board satisfies our requirements, because we don't have any. So my thought is what Mr. Verbicas couldn't have possibly answered is what we're thinking. And it's really up to us to decide if the application could harm the wetland.
Well, that is true. That is
okay.
true. I didn't hear Dinus's statement, so I'm not sure whether he was trying to say that the applicant has amended and redesigned such that it will not impact the wetlands. Maybe that's what he was trying to say. I don't know.
He was very, very careful in his word selection. And it just occurred to me that he basically had said that it meant our non-requirement.
Okay.
Well, in any event, you do get to look at, if there's evidence in front of you, whether stormwater is going to have an impact on the wetland.
Thank you.
Okay, and I'm going to make a note that we're going to want to review that before we make a decision. Anything like this that we come up with, we should be reviewing, I think, prior to a vote, because there's been a lot of testimony to try to remember it all. Carson?
And I'm not basing my decision on that comment. I just felt like it could have been confusing for people, and I wanted to sort of clarify that. Yeah.
Right, understood. Just if it comes up as a point of this is part of our decision, I think we actively have to go back and look again to make sure
Okay.
we're not putting words in or taking them out of his mouth. That's all.
Okay.
Carson?
Thanks, Susan. Yeah, and to give my thoughts on what Mr. Beecher and Tracy were just talking about. And I had a specific exchange with the applicant on that very issue. I think both in this case and the other large one previously. I get it, right? Because the engineers are given a task to design something that fits on this property. And what do they use to do that? What are their guidelines? Well, they use previously the 2004 stormwater manual, and hopefully now the 2023 proposed. They use the planning and zoning stormwater designs criteria, and they use those as guidance to kind of give an initial design. And I think I'm not sure whether it confuses them or whether they're just not sure how to proceed when they put something in front of us and we're not happy with it, because in their mind, they complied with the guidance documents they had in front of them, which are a good starting point, which is what I told them before. But if that was the end point, then we wouldn't need to exist, right? Because you just have to compare what they're proposing to the guidelines, and someone could administratively go through and be like, oh yeah, you're good or you're not. The purpose of this board is much deeper and much more focused on the, like Mr. Beecher said, all the evidence in front of us. So I understand the confusion, but the way it's been presented to us from a couple applicants now is that if they seem to believe that if they comply with some of the guidance in some of these guidance documents, like the 2004 stormwater manual, that we should be fine with it. And I think in some cases that may be the case, depending on the wetland and the other facts in the case. But in some cases it may not, and that seems to be what confuses them.
Anyone else?
Yeah, I have a question for Tom.
Sure, thank you. Go ahead.
Yeah. I have in my notes here that there were two issues that stood out to me. One is that salts, nitrogens, and chlorides do not get filtered out by the separator that they plan on putting in for to deal with runoff and snow melt. I'm just curious, is that enough for me to reject the application, or do I need to have other evidence that would support that?
A little tough for me to answer that question in a vacuum because I wasn't present for all the testimony, but what you want to know is whether those items are going to end up going through the system to begin with, and then whether there's evidence that they actually will not be filtered out and they will actually find their way into the wetland, and that will cause damage to the wetland.
Okay.
So there's a little bit more than just someone said, well, it doesn't filter these things out. Well, those things might not ever be going in. I don't know. But ultimately you want to have, if you're looking for a reason to deny, and maybe you're just exploring that, ultimately you have to have good evidence. And I know there's people on this board with their own expertises, but you want to have credible, preferably expert testimony that there's going to be some actual impact to the wetlands if this project is built. Not speculation, not maybe, real impact.
Okay, thank you.
Anyone else? Questions? Comments? Maybe as a point of discussion, setting aside how wide the buffer area is in this plan, are we happy, unhappy with the planting plan?
Well, I think I'll jump in quickly. Just having had the discussion with the last application. Similarly, we're for Tracy and Alan's points. on a slightly steeper sloped property. 10 feet wasn't adequate. 20 feet was obviously twice as good, but I think it's site specific, and this site is relatively flat, but I guess that is the question. I think it could be a little wider and more robust planting plan, since most of it is impervious, whereas in the other application, we're looking at just manicured lawn. So I think for me, I would prefer to see a wider, more robust buffer, and the little grass area is also, pretty ecologically, of little value. So given the amount of impervious surface and building asphalt, I don't see that buffer width or quality adequate to protect wetlands and watercourses that are off-site.
Alan?
Yeah, my own feeling about, I'm speaking as a landscape architect who has done many wetland mitigation plans. I thought my opinion, I think that what is being proposed is rather, the term I'll use is sparse and paltry. There are very few plant materials which are being proposed, and it's also very narrow. The width of the planting area within the upland review area. And I really do feel it could be significantly larger, wider, and I'll say more densely planted than what they're depicting on that plan. And I think that would be would provide a higher level of protection of the resource of the wetland itself. That was my, let's call it opinion on what was shown on that plan.
So is it okay?
Tracy, yes, you can go ahead.
So I agree with Alan, and I went back and I looked at our code and how we're supposed to make decisions, and I guess a couple things stick out to me. And one is we heard from a soil scientist who is duly qualified, who certainly recommended a wider buffer to mitigate any overflow, the temperature of the overflow. And so that sort of takes me to our regulations that say that we're supposed to consider any activity which substantially diminishes or has the potential to diminish the natural capacity of the inland wetland or watercourses to support desirable fisheries or wildlife or other living organisms. And the biologist certainly was concerned about that. And
excuse me, I'm sorry, Tracy, just for the record, which biologist are you referring to here?
Dr. Danzer, the licensed biologist. And so that to me just says it right there. And he also, I asked him, again, at the end of the meeting, seeing the revision, he still stood by his recommendation for a wider buffer. So just speaking to the buffer, I sort of fall back on the soil scientist testimony.
All right.
Can I follow up on that a little bit, if you don't mind?
Yes, Tom, please.
Tracy, I would just point you also to section 10.6. I know that your final point was about the need for a better buffer, and that's okay, that part. But if you're talking about the impact again on salamanders and so forth.
I'm not.
Okay, good.
Yeah, I'm not talking about the impact on anything upland of the wetland. I'm really concerned about the actual wetland and the habitat in the wetland,
Right.
which is where our jurisdiction is. And the soil scientist said that because the outfall, so I don't know if you heard this conversation, but my concern was that that first flush of rainfall hitting all of the asphalt and roof asphalt, and then getting piped into pipes and then sent to a detention basin. It's all a closed system. It's not mitigating temperature, and then the overflow, the outfall of the overflow was just 25 feet away from the wetland. And so I asked the soil scientist if that was a wide enough buffer to handle the increase of temperature, considering the sensitive diatoms and aquatic species within the wetland. And he said, in his opinion, it did not. So that's where my concern lies primarily.
Okay. Thank you.
Thank you. Anytime you hear me say something that you question, please speak up.
Yeah, that's
I just
That's
wanted to
critical.
clarify the impact on
Yes. I'm speaking solely about the
amphibians.
sensitive species within the wetlands and watercourses.
anyone else at this point?
On another topic, Sue, I
Yes,
don't know if you
please.
have it on the list.
I
I
don't
wanted to
have a
just-
list.
Uh,
Whatever you want to talk about is fine.
and just on the topic of feasible and prudent alternatives, because I think it's a big factor in reviewing these applications and then rendering a decision for approval or denial. But I guess I just wanted to open that up to have that part of the discussion and gauge people's interpretations of what's been presented so far, or what could be a feasible and prudent alternative. Because in my opinion, there are some that exist and have been presented, as well as what has the morphology of the application as compared to when the public hearing opened versus where we ended and closed the public hearing. I think the project changed. The applicant did make some changes at our request, but I think what sticks with me the most is which was brought up by the applicant several times was we have how there's existing approval from the previous board for a much smaller construction unit with although it was close, if not closer to the wetland or within what we're calling the buffer on the existing plan. To me, I think it was I recall it was 3 units instead of 14. To me, that seems a significantly less disruption, possibly a temporary and permanent disruption to the upland review area, and to me that does seem like a feasible and prudent alternative. I just wanted to get that discussion started and get people's thoughts as we talk about that part of the application.
Tom, question for you on that. Apropos of that, the applicant suggested that they could, of course, which is absolutely true, go ahead with the plans that were already approved and are going to stay approved for some time. That they could later on come back and, for example, take down the house that's over 100 feet from the wetlands, and they wouldn't have to come in front of us because they would do something that would keep it completely out. Is that true?
It might be, but remember that you have jurisdiction beyond 100 feet if you determine that a greater upland review area is necessary within the proximity of a wetland or a watercourse. So, it may or may not be true. But in terms of the feasible and prudent alternative, remember that's a balancing test between, appropriate use of property and protection of the wetlands. And so, you know, if you are thinking of maybe an approval with conditioning of a more robust and wider buffer, then you may be creating the most feasible and prudent alternative by doing so, and therefore can approve with the conditions. If you're leaning elsewhere, just remember that, you know, is this project as designed or as conditioned truly going to have an actual adverse impact on a wetland? Otherwise, you don't need to talk about, well, they could just go back and build what they'd already got approval for, or certainly an alternative always is, well, there's a single family home there, so that's all you get. See you later. So that's not really the balancing test you're supposed to do.
Okay, that's, I think, a very important comment. That an approval could conceivably come with a condition of a wider buffer. Is that within our,
Yes,
that's within our right?
you have the ability to not only approve or deny, but to modify and approve.
Good, I'm just trying to understand that. And then there was another alternative, just to get done with alternatives, that had the whole building with the same sort of density, more units, but smaller, and a garage underneath, completely outside of the upland review area. That looked to me like it would still come in front of us because of the need for stormwater management. Is that the case?
Well, again, yeah, depending on the design, it's certainly it's going to have to go to the land use office for a determination as to whether it ought to come before you.
Okay. All right, that was. So, anyone else? Other questions? Comments?
Yeah, going back to what Tim had brought up, that it seems to me I've never understood their argument about going from a 3-unit development up to 14, and that there was nothing even proposed really in the middle. And I don't understand the necessity for having a 14-unit apartment complex. It's not based on anything to do with the wetland. It does seem to me that more people have more impact. And I know that if there are more people, there's more people that are going to be, you know, walking across that buffer and doing other things. So I really think that they have not, as far as I'm concerned, really even visited a prudent and feasible alternative.
Well, my reaction to that would be careful about the one about speculating about how many people are going to traipse through the buffer, speculating that they're going to dump trash out there. I think there's other issues you should probably better focus on.
Okay.
Just speaking as an attorney who might have to defend an appeal.
Okay.
Yeah.
I'll keep my mouth shut then, Tom.
No, just on that one.
No, I think it's true. We have to keep our focus on what is in our purview and what isn't. And if we approve it, we're not saying planning and zoning is going to like it or approve it. We're only saying that they're not doing damage to the wetlands if they do this. It's, in a way, it's kind of weirdly hypothetical, I think, and you know, that what we're looking at is in fact a plan, but it's not necessarily the final plan because we don't have the final say. So, Carson.
Well, that's not
I'm
always,
sorry, Tom.
yeah, I'm sorry about that. That's not always true, because if there's significant changes required by another agency, it may well have to come back to you for a modification. So keep that in mind. I mean, you get the first crack at it by statute. You know, the application has to be submitted to you before or simultaneously with, and then you have to report to planning and zoning before their time clock expires, which goes beyond yours. But, you know, and it's unfortunate sometimes for applicants if it's a back and forth situation, but I just wanted to clarify that it may well have to come back to you if there's significant changes required by another agency.
Thank you. Appreciate that. Carson?
Thanks, Susan. Yeah, I just wanted to comment on, kind of take off on what Chris was saying and on what Tim proposed we talk about. I think, you know, well, and Tom, correct me if I'm wrong, but so the first thing we have to decide, at least individually, right, is whether we think there's an adverse effect on the wetlands based on the proposed application. And then if there is, then we have to see if there's a prudent and feasible alternative or not. So, I mean, conceptually, if there is an impact, what they've presented, even if there is an impact, could be the most prudent and feasible way to handle the property, right? But if there's no impact, then that doesn't even come up.
That's correct. And so going back to, well, they went from 3 units to 14 units. Well, there could be a project with 50 units that has no impact on a wetland. So it's not the number of units so much as, you know, it's the baseline. And Carson, you're correct. First question is the project as designed, will that have a permanent adverse impact on the wetland? And if your answer is yes, it's likely, or yes, it's going to be actual, then you can also say, well, can we do some conditions that will mitigate that or vitiate that? So, you know, the baseline is, as designed right now, is that going to have an actual impact on the wetlands?
Thanks, yeah. And so, Chris, I think in this case, and they said it multiple times, their attorney said it multiple times, they don't think that there's going to be an impact. So whether 3 or 14 units, you know, that whole change they think it's irrelevant. I happen to believe, based on the evidence in the record, and we can talk more about this as we get further, but I think there is going to be an impact. I was a little disappointed because I thought this one might go differently than the previous one, because they went back to the drawing board and asked us specifically what we were looking for, and then they didn't provide it. So they made choices, and but I think that's the biggest thing for me, right, is that regardless of how many units you have, the distance between what's the effluent and the wetlands is too small to handle the things that the drainage system doesn't handle. You know, like Chris said, the salts and all sorts of other, you know, organic vegetative flow, you know, natural processes are required to handle these things. And in some cases, when it's a small amount of water and if it does actually infiltrate into the ground under these systems, that should handle it. But for the bigger events where it's either, you know, bypassing the system, or it's certainly not being treated by the system as in the way it's supposed to, if it's a large event, all that stuff is coming into the buffer before it gets to the wetlands. And if that buffer is too small, then you've got a lot of bad stuff going into the wetlands that's detrimental to the wetlands. So for me, I feel like there is an impact. And then when you get to the prudent feasible alternative, there's seems to be a prudent and feasible alternative existing now, which is the single family house. And the permit that they previously acquired, you know, although, you know, from our perspective, it's it may not be as feasible because it's closer to the wetland. I think in general, it's a more prudent alternative. So there do seem to be other things. And what I had specifically asked them for, I said, look, you know, if the concept of this design, if you pull it further away from the wetlands and actually work on a buffer that some of the experts were talking about, I think it was somewhere between 80 and 100 feet. I'm not sure in this case, from my personal view, based on the quality of the wetlands, it needs to be quite that far, but we at least wanted them to get out away from the canopy of the trees, and we had some thoughts about that. And they really didn't budge on that, right? They adjusted the stormwater design in a few things multiple times, small tweaks, but making a larger buffer was a variable that they decided not to change. And I think that to me, you know, is going to be detrimental to the wetlands based on the things that are going to be going in there. So it's unfortunate that they didn't, you know, put in some of those recommendations in my view.
Tom, can I pose a question on that subject?
Sure.
Okay, let's say you went back and you conditioned it on, okay, we're okay with this, except you need a wider buffer for all the reasons Carson just said. What are their options? Their options would be, one, I guess, assuming that, they could appeal it and say that's not reasonable, we proved our point. Two, they could go back and make a minor adjustment to the plan, or maybe not minor in their minds, but some adjustment that gives us the distance we're looking for. And that's not for us to tell them how to do that, I assume. Or they could withdraw and put in a whole new plan, correct?
Now, that's generally correct. I mean, if you put it in as a condition,
Yes.
their option, of course, is to then go and pull a permit and provide Caleb with a revised set of plans that show that condition, basically the more robust planning plan and a wider buffer on that plan. What I don't know, and I didn't bring a copy of the final site plan with me, I don't know if the wider buffer and pulling back the outflow impacts the building itself. In other words, if you oppose that condition, are you really redesigning the whole project? In which case, then maybe we should not go there.
Okay. I think that everyone understands the answer to that one.
Just adding to Susan's question, I feel like we did ask for that multiple times. And each time they didn't come back with that. In the last one, I think the outflow was even a little bit closer than the previous, although they did move the basin. So we did ask for it multiple times during the course of the meetings. Yeah, I guess just one last thing I'd like to add, in addition to the thermal pollution, which is a serious pollutant, we also heard testimony from Mr. Trinkus that he was concerned about the system actually doing what the applicant said it would do in terms of removing pollutants. So we had sort of testimony that conflicted, so my understanding based on reading our code is that we can take all of that testimony into account in our decision making. Is that correct?
That's correct. And you also, as a board, get to make a determination as to which experts you find to be credible or more credible.
And just adding to that, when we asked Mr. Verbicus and Mr. Trinkus about how they were coming up with their calculations in terms of using the testing results from the manufacturer versus comparing it with other testing results, both of those engineers said they typically don't just use the manufacturer's testing results. So that was another consideration for me, that it could have been a more robust system, as Alan said.
Okay. Anyone else at this point?
Yeah,
Chris.
Tracy, to your point, one of the things I heard them repeatedly say is that they were fulfilling Ridgefield, Connecticut, and the 2004, I believe, reports and statutes on water quality. But in my mind, something from 2004 is not relevant in 2023. And I don't know what standing, I don't know. I just don't feel that that's enough to state as evidence. It's almost 20 years out of date in terms of its relevance to research that's going, or to the impact of environments today. It seems to me we need to have a higher standard than what was something 20 years ago. That's just my thought. Well,
The 2004 Deep Stormwater Quality Manual is the Bible still, until the new one is approved and released. So in fact, that's the one that people strive for, but it is a guide. So if the applicant says we meet or exceed the requirements of that guide, that's a wonderful thing. And that's great. But if nevertheless you have very good evidence or credible evidence that despite that fact, that sediments or nitrates or what have you are going to get through, and the fact that they get through also will ultimately have a permanent impact on a wetland, then you've got something to talk about.
Thank you. Carson?
Yeah, Tom stole my thunder there. But that was basically what I was going to say. No, but I think to Chris's point, there is, and we talked briefly about it, and I think the applicant's engineer talked about it, and I think for the most part on the drainage portions, I think a lot of parts of the application were pretty sharp, and they did, like I said, they did make changes based on some of Alan's comments. I think in the end, I think the retaining wall and the drainage system around it and behind it that was proposed at the end was better than the original design. I liked it better. So they did make some small improvements there. But I think one of the big things is in the, what guidance we're looking at. And yes, technically the 2023 is in draft form, the new stormwater guidance, but they stay in effect for a long time. I can't remember, Alan probably knows, but before the 2004 standards, it was probably another 10, 15 years between that and the previous standards before they were replaced. But
that was probably the Nationwide Urban Runoff Program of 1982.
Okay, so even longer.
It's that long.
I wasn't going to say anything.
So the guidance isn't updated that often, but I think the new document does make some good changes. And I think one of the things that it does that we talked about both in this application and the other is it concentrates on, and a lot of acronyms here, but the BMPs, right? The best management practices. It concentrates a lot on the LID or the low impact development processes, which are the rain gardens and the bio swales and filters and all that kind of stuff. Basically natural processes. They're saying they want you to consider those first and use those to treat the water. And then if you put it into a drainage system, and you might need, separators and all sorts of stuff like that. And in this and the previous application, they've really kind of tried to avoid, to a large extent, using any LIDs at all. And when we've asked them to implement them, they've not, right? Because the biggest problem with putting LIDs in place is they take up space, which means that you're not going to be able to put as many buildings in because you need more space to treat the water. And that's the one variable in this application and in the previous one that the applicant has refused to change, is how many buildings are in the application. And that makes a big difference.
Mm-hmm.
Can I add to that?
Yes, of course.
So it strikes me that though I read that too, but just I remind myself that that's in P&Z's jurisdiction. But you could say that as a result of their not implementing those, we're left with this decision of the thermal pollution and the outflow of it so close to the wetland. So for us, I guess we can't require them to use best management practices that are outlined in P&Z's code, but we can say that as a result of the decisions that they have made, we're concerned about the thermal pollution, and also we're concerned about the testimony of one of the engineers who's also concerned about chemical pollutants as well. Is that correct, Tom?
Well, yeah, you can't look at the zoning regulations per se, but when you're looking at it on what improvements can be made to protect the wetland, then you certainly can look at anything.
Okay, all right. So then that goes back to your statement, Carson, then that exactly what you said.
Yeah, and I think Tracy, like, so, and this didn't come up in this case, but it's just you know, in the previous case, you know, personally, I think a 10-year storm design for a stormwater system, you know, that's not what I have at my house. And in some cases that may be fine. Like I said, if a parking lot's going to flood every 10 years, maybe it's okay. If we're talking about a wetland, or particularly an important wetland like an open water course or a pond or something, even though P&Z regulations say that they need to design a stormwater system to a 10-year storm, I would, in that case, or cases like that, I would probably say, well, it needs to be better in this case because it's not a parking lot; it's a drainage system right next to an important lake or whatever. So you have to up the design criteria and protect things better. I don't think that's an issue in this case, because I think they did actually, like I said, I think they did a pretty good job with the drainage in general, and they designed it to higher storms already. So I think from the drainage side, they did a pretty good job on this one, and that wasn't an issue. But on the you know, kind of the bioremediation of the water, the natural processes and the LIDs, that's where I think they were deficient, and I think that, you know, the evidence shows, and that's why it's in the new manual, that you know, can have a detrimental effect on the wetlands if you don't use processes like that to treat the water.
Yeah, I agree. I wasn't concerned about the quantity of the water, but the quality of the water.
Yeah, same.
The outflow, right?
Anyone else want to comment specifically about that? Okay. Any other topics? Okay. Oh, sorry, Alan.
Oh, thank you. Thank you, Susan. Perhaps I would like to still have this discussion regarding the walling off of this property. I know, Tom, that we discussed it up front, or you discussed it up front with us. But again, I have concerns regarding the 5-foot height wall that is being proposed. And I guess from a couple of aspects. One was from a prudent and feasible alternative perspective. It is something that I had requested that they look at an alternative without having that wall that runs parallel to the, you know, the eastern boundary or the wetland on the property, in order to facilitate, I'll call it amphibians in their life cycle, being able to transition from the wetland to the uplands and upland review area that they do normally. And so that was a concern of mine, very much so. And I was very disappointed that this applicant never considered that alternative and came up with a prudent and feasible alternative based on that comment. The only prudent and feasible alternative that they had based on that comment was that original plan, which was, I guess, approved by the combined Planning and Zoning and the Wetland Board several years ago, you know, prior to our advent. So that's a concern of mine. And maybe, Tom, you can address this too. My concern is that in situations like this, where you construct a wall, a tall wall adjacent to a wetland, you know, to me, it has the ability to be a precedent that other properties adjacent to a wetland can point to it and just say, this board approved it previously 10, 15, 20 feet away from a wetland. Why can't we put one in as well? And so what happens is you end up building a wall around a wetland. And although this project might not be the one that, and I'm not necessarily convinced it isn't, but trips the significant impact on the wetland, taken together with other projects, it would. And there have been other projects in this town, and I won't name them now, but there are other projects in this town where a tall wall has been built adjacent to a wetland. And I thought, you know, it had the potential to be very detrimental to that wetland. And that's a concern of mine. And I was just wondering if how others feel in this regard, and whether or not we can I'll just use the term, deny this on the impacts, and there were impacts that were negative impacts, which were noted by Mr. Danzer in his comments. You know, from the construction of this wall around the perimeter of this site. I mean, I would agree that, you know, they were able to address the stormwater comments. They were very creative, and their modification of the wall to one which would not require deep footings, I thought was reasonable, you know, in this regard, you know, to avoid what I had termed the bathtub effect. But I'm still concerned about constructing a wall on this property and, you know, its impact on this wetland and on the amphibians and reptiles that are surely resident in this wetland. It's a significant size wetland area still. And so that's a concern of mine here. And I don't know how others feel about it, or I don't know if, Tom, you want to weigh in on this as well.
First, let me just read the language in the statute itself. A municipal inland wetlands agency shall not deny or condition an application for a regulated activity in an area outside wetlands or watercourses on the basis of an impact or effect on aquatic, plant, or animal life, unless such activity, meaning the project, will likely impact or affect the physical characteristics of such wetland or watercourses. So, you know, in your analysis, it might be that last applicant on some other end of this wetland that wants to propose the last stretch of wall that might be faced with that burden. But here, you know, does your record have evidence that a significant population of salamanders or frogs or what have you traipse in and out of this particular project from the wetland and back to the wetland? And is there evidence enough to say that, well, this wall is going to interrupt them to such a point that they're going to move elsewhere, in which case they won't be removing detritus from the wetland and so forth and so on. So in other words, it's a bunch of dominoes, and you know better than I because you've sat through the whole hearing, but it's a bunch of dominoes that you have to make sure are set up properly before they fall in the direction that you're talking about.
Tracy?
I think from my memory, this has come up before, and so we actually had Darcy come and talk to us about it, and she was pretty clear that we only have jurisdiction over the aquatic life within the wetlands and watercourses, and even if there are endangered species that are using the area upland, unless those species in the upland area actually benefit the wetland. So for an example, frogs that leave their eggs in wetlands and then aquatic species eat those eggs. And so that benefits the wetland. Unless we've provided evidence of that to the record. So for example, if we had a scientists go onto the site and find the wood frog and document all of that, and we add that to the record, I don't think we can make our determination based on that. That's my understanding. It's only, we don't have jurisdiction over species in the upland review area, only activities in the upland area that could harm the species within the wetland. And I know it's such a fine line.
Yeah, or harm the wetland itself. I mean,
or harm the wetland itself, correct.
This is an outlier case. There was a proposal to build a golf course, and they were going to clear cut all this forest land. It was going to impact the wetlands. It was going to impact wooded tree frog, I believe. And because of the significant population that would ultimately move elsewhere because of the clear cutting of, 50 acres of land, something significant, that the conclusion was that the absence of those frogs from the nearby wetland would make the wetland, would impact the wetland because it would deteriorate. the frogs wouldn't be populating and doing their thing and cleaning out the wetland and so forth. So, but that was a significant case. But in that particular case, the fact that the frogs populated outside of the wetland, nevertheless, if the impact on the population was such that it would actually impact the wetland, and therefore that was within the statute.
Tracy's your hand still up, or?
Oh, I'm sorry. Generally speaking, it's in a sense, it's because that's where the science has left us. I mean, the science has only found that this particular frog benefits the wetland. It may be that other species also benefit the wetland, but the science hasn't caught up with that or told us that, so we can't identify it in our decision-making process. Our hands are sort of tied. That's my understanding.
No, that's correct.
Okay. Chris?
Yeah. Yeah, so in my mind, I know that amphibians, frogs, salamanders, turtles, all those, I mean, a turtle's a reptile, but this idea of salts, nitrogens, and chlorides getting through the filtration system and going into the soil and into the wetland, that's going to have a negative impact on an amphibian for lots of different reasons. They have very delicate what do you call it? They have very delicate systems. They can only take so much pH and other chemicals into their bodies, and I just think that's a major concern of mine. And if their system doesn't satisfy that, then that's as much as they tried to alter it. It's based on what Mr. Trinkus said. The system's not going to take those things out.
And I'll just add to that, like, we don't have to take our word for it, because we have the testimony of Dr. Danzer who said as much. And so, yeah, that's how we know that, right.
Okay. But I don't think what we don't have in the record that I could find was anyone telling us how much we should have. Our own peer reviewer said something like 50 feet, and Mr. Danzer had a larger number. But if we were to try to take this and say, okay, we're denying it because we, how do we assign a distance to that? And quite frankly, how will the judge look at that as opposed to, for example, the public good of having more housing?
Well, I don't think we have.
Where do we find that in the record? That,
well, I think we can simply say that in the record we have the testimony of Dr. Danzer, who has said this isn't enough, and he has recommended 80 to 100 feet. And I think that's our testimony. That's our information in the record.
okay, but
is that
in a way that's not helpful to the applicant should they decide to come back? Because that leaves it, well, they'll decide 50 isn't enough. I'm just playing a little bit of devil's advocate here. I think we're going to have to justify it somehow, and that's my
so
question.
many opportunities to come back and test out other options. I mean, multiple times, and we asked for a bigger buffer every time. We were very consistent, and once we received our testimony from Dr. Danzer, that sort of clarified for me that what we were requesting was appropriate. So I suppose they could submit a new application if, I don't know how that works, but and they could always come back if they wanted with a different application. Is that right?
Yes.
That's one of their options, correct. And the other would be that we have to defend our decision. And I just think we need to be sure. And personally, I'd like to go back and read things again since we seem to have narrowed it down to this is the issue, really, correct? Am I misunderstanding people here?
You're saying buffer, Sue?
Yes, if
Yeah.
this is what is in the end a sticking point for us.
Well, 2 points, that the buffer, and we did see a prudent and feasible alternative that had everything outside of the buffer. So those, it's actually 2.
Well, which one are you considering to be the feasible and prudent? The one with,
Well, I think you brought up the one where they basically showed everything outside of the buffer.
okay,
So that is clearly a feasible and prudent alternative.
okay.
I mean, that's, do you agree, Attorney Beecher, that makes sense?
Well, the first issue is what is the damage to the wetland? And so you're saying that the outfall and so forth are too close to the wetland. And therefore, as Susan points out, okay, what are we telling the applicant might solve that? And it's a greater buffer. Not, not buffer per se 100 feet of the whole URA, but a greater distance from the facilities to the wetland is what you're really trying to create. And is that the only issue that is your potential basis for denial?
Well, I guess the other issue would be that Carson pointed out a more open system, vegetated swales, rain gardens. These interventions would have been very helpful in addressing the thermal pollution. And so I guess that would be another alternative in addition to a greater buffer.
Well, so those are deficiencies, and therefore the alternative is something that actually incorporates those. In other words, you can't get to the feasible and prudent alternative until you've defined for yourselves what the actual deficiencies are that will damage the wetland.
And I think we defined that the closed system increased the thermal pollution and the location of the outfall so close to the wetlands so that there wasn't enough buffer to mitigate that. And then Chris also identified concerns about chemicals that Mr. Trinkets was still concerned were not being dealt with. Those were, in my mind, the deficiencies, but were there others? Alan?
Well, I'll add in if you're asking me. Sorry, Carson, I'll just butt in here. One of the other deficiencies in the design to me, I mean, it may seem petty, but is the snow removal area. I'll give that as an example. Their snow removal area is one of the most inaccessible portions of the property shown. It's, adjacent to the easternmost unit. And and I know that that's not how it's going to go. What's going to happen is that the contractor who comes in and clears snow is going to dump it over the wall and into the planted mitigation area. That's what's going to happen. And whatever materials are in that snow, pile that's removed is not only just going to damage the mitigation area, it's going to have a clear shot straight into the wetland. So without any treatment. I mean, to me, that was a real deficiency in the design of this project as well, because there's no way that someone is going to pile this snow where it's shown. And I just want to make sure that's known as well, that this is a major, to me, that's a big deficiency in this plan. While you're talking about various, thermal pollution and perhaps nutrient pollution, to me, this is a source of nutrient pollution, another sediment that's going to go straight into the wetland.
Okay, we'll go back
Sorry.
to Carson then. No,
Sorry to
that's
interrupt
okay.
you, Carson.
It's okay.
No, that was good. You're getting me all fired up. No, I appreciate that because I wanted to mention that as well. Yeah, a lot of people snowplow and put the piles 90 degrees from the path of the vehicle, right? It just doesn't happen.
Straight ahead.
Yeah,
Yeah,
there's no way
yeah.
they were gonna plow that.
Correct.
And so, yeah, for me, which we asked for, right? The increase in the buffer does several things, right? It helps, and whether it's a planted buffer, whether it's a buffer that you're using LID practices in, whether the part of the buffer is before or after the stormwater, you know, it's helping a lot of those issues, helping the nutrient issues, because you've got natural processes that are taking care of a lot of those. If the snow gets dumped over there, then you have a much longer distance between where it's being dumped and the wetlands, so that again, the natural processes can help mitigate that. So yeah, it wasn't just the fact that the buffer was too small. It was the fact that the reasons that you need the larger buffer could fix a lot of the problems that we foresee happening in the wetlands based on the current design, right? And that was one of the issues, was the snow removal, and the other was, yeah, the LID practices. You know, and I know grass doesn't get a good rap, but like the existing conditions there now, right? It's a long grass, you know, strip to the wetlands, which that is, it's natural processes still, right? You have a pollutant load that comes down on there, it's getting handled because that's what Mother Nature does. And I know, you know, they're taking the grass out and they're putting in wetland plantings, which are better than no plantings and probably better than the grass ultimately. But the amount of grass you have there now compared to what they were proposing, you know, it's night and day. And, you know, there's a lot of treatment happening now that they would be removing, all for the sake of getting in another unit or two on the end of that building. You know, so that's the issue. And I think, yeah, we've identified several reasons why we think there's going to be impacts to the wetlands itself. And as far as prudent and feasible alternatives, you know, there's a couple of things that they had proposed that seem prudent and feasible. Again, similar to the other application, they didn't go into a lot of detail. So what we were presented seems to be more prudent and feasible with respect to the wetlands. And then based on our suggestions, sort of like Tom just said, if we're suggesting the buffer is between 80 and 100 feet, again, I haven't seen what that does to the size of their building and how many units they can squeeze in there or not, or how high it has to be. But whatever size building fits on there, with the buffer being 80 to 100 feet and having LID practices and things that are going to take care of these pollutants, that would be the prudent and feasible alternative, right? But we haven't seen that, even though we asked for it.
Anyone else?
I would just piggyback off of what Carson just closed with.
Tim, yeah.
I think that what he suggested covers a lot of what we just had a discussion about in the last half hour or so. A few less units on the end gets us the bigger buffer. You know, to Tracy's point, less impervious and asphalt impervious surfaces and roofs, where rainwater that's going to hit, you know, 130-degree temperatures and go right into the ground and out. Obviously less soluble compounds, inorganics, and then the opportunity for a different snow staging location and just a wider buffer. I think we haven't seen that, and I would be more inclined to support that design than what we've seen.
Okay, we did have our own peer reviewer suggest 50 feet and reference a document from DEEP that suggests that as useful in an area where you have an intermittent stream. And then we have Danzer saying, well, really should be more than that. But I think we should consider both of those comments. The other thing I'm not sure about, Tracy, is I think the applicant responded on the thermal issue, whether or not that's in disagreement with one of our peer reviewers or one of the applicant's peer reviewers, something to the effect of, oh, well, if it's underground, the ground stays cooler, and before it gets out, it will cool.
Yeah, it's not the underground movement of the water that concerns me. It's the overflow.
I got you. Okay.
The overflow is still just you know, it's going through the level spreader, I understand, but it's still just 25 feet. And after the applicant responded, we went back to Dr. Danzer and asked him if he felt the system was managing the thermal pollution. And he said, when it goes through the ground, it's fine, but the overflow, no, that 25 feet is not enough for the water that's going over land. So
I also remember him saying, I think it was Dr. Dancer or Trinkus said that whatever temperature the water is when it hits, it's going to stay that way for a significant period of time before it does cool.
Mhm.
The typical groundwater coming out of the ground out of either overburden or fractured bedrock aquifers is anywhere between 50 and 55 degrees. If this is rainwater hitting 130-degree asphalt or a roof in the, say, the summertime, and even if it goes into the ground, it's going to decrease, but it's not going to be 50 to 55 by the time it exits the level, in my opinion.
well, again, it was the overland flow that
Right.
that Dr. Danzer was concerned with, and he said that 25 feet was not enough to mitigate that temperature before it hits the wetlands and watercourses, and it would impact the species that live within it.
Which I share that concern, Tracy, because, you know, as we've seen, most of this, extremely high percentage of this site is being paved and or roof. So we have black asphalt everywhere,
Right.
and storms are not getting any easier. I mean, tonight they're saying we might get 2 to 5 inches, which is, you know, huge percentage of our annual rain.
And that is one reason.
Where would that end up?
Sorry.
Yeah, go ahead.
That is one reason that the best management practices recommends this sort of multi-system open approach to mitigate temperature, and it recommends against collecting everything through pipes and sending it to one place. And then in addition to that, the outflow in this case, it's all going through pipes and going to one place, but the outflow is still just, according to Dr. Danzer, just too close.
Mhm. Yes, I agree with Tim that the rest of this site is going to be notably non-shaded.
Right.
I mean, there's no opportunity to,
No room for trees.
no room for trees. I don't know if you could develop some huge pergola to put over the whole thing, but basically it's unshaded and there's nothing that can be done to change that if it's built as it's shown. I don't see any place you can put trees.
Maybe a green roof, maybe some vegetated swales, some
There you go.
gardens. I mean, you
That,
definitely
and
have
I
to
would go
change
back
the
to
plan.
our point earlier of less units, more room for, you know, other
Well, that's up to them. I mean,
favorable practices.
they could
Correct,
stack
that's not
them
us to
wherever they
say.
want, but
Yeah.
yeah.
Okay.
Exactly.
That goes to Carson's point about LIDs or the lack of LIDs, actually.
Right. Okay, well, it seems to me, if there's no further discussion, that we're looking at defining why we think this plan is deficient. I personally would like to, now that I'm able to focus on what everyone's concerns are, and including my own, I personally think I need to go back through some of the testimony and some of the records just to be sure, because we're going to have to put together a document that doesn't have any flaws in it, such as, oh, well, that's not on the record, or that's not what somebody said. Does that make sense?
Very much so. That's very wise.
as you get picked apart pretty quickly on those kind of little things. And we've got 2 weeks to put in the time on it. And find what there is to find. David?
Yeah, I agree. I've been taking a lot of notes, but I feel the need to go back over a lot of the reports from our expert, our peer reviewers, and some of the testimony. I just feel the need to refresh a lot of the information.
Right, and you can get, Artie can, or the office can send you links to whatever meetings you would like to review. I think obviously the later ones are probably more useful than the earlier ones, because the plans did have some changes made. So if there's nothing else, I would like to continue the discussion to our next meeting, which takes place, help me out, Artie, my calendar.
October 12th.
Thank you. I'd like to continue the discussion to October 12th, if I could. And keeping in mind that depending on what we come up with, very specifically, we have to come up with whatever we have on the record, not anything new or different. Then we can put it together and either vote on it or agree to get a resolution. And then it would be up to the applicant to either give us the extra time for that, or we would have to deal with it all in the next meeting. Or if they didn't give us the extra time, we could just say, well, we need more time. So Mr. Beecher, is that correct? That
I would suggest getting it done within the time frame you're allotted. Not sure how willing applicants are to give extensions based on the conversation tonight.
okay. Would that suggest that we need to come up with
I think that if staff and I and you perhaps put our heads together, we can at least put together a very good skeleton of a draft denial, and then can be filled in as the conversation goes at the next meeting. The other thing just to keep in mind is that we will also be prepared to deal with the two-part question for you, which consensus seemed to answer the first question affirmatively, which is in terms of intervention, is the proposed project reasonably likely to impair a wetland? It seems the consensus is yes, as designed right now. The answer is yes. And then the second part of that you'll have to answer after you've reviewed everything is whether that impairment is unreasonable, which if you end up denying the application, I think the answer would also be yes.
correct? Thank you for that. I think it's been very helpful to focus our thinking. Chris?
Yeah, I have a question for Artie, actually. And despite being on the Inland Wetland Board, is there a way I can get hard copies of testimony and kill a few trees while I'm at it?
If they have uploaded it on the application, we could provide it.
Okay, thank you.
Okay, so I guess this is continued to the next meeting, and staff will try to put together whatever is possible from tonight's meeting and have that ready. And meanwhile, we can check all our documentation, make sure we're absolutely right about everything. And so I would ask everyone to do that and come prepared. As Mr. Beecher says, the applicant may prefer that we finish next week and not want to give us the extension. Okay, thank you. Appreciate that. Go.
Thank you, Tom.
Thank you, Tom. Are you saying then you will be available for the next meeting or not?
Right now I'm booked at Danbury Wetlands,
Okay,
but I'll see what I can do about that.
okay.
Thank you, Tom. Thank you, Susan.
Thank you very
Tom.
much.
Thanks,
Thank you,
Sue.
everybody.
Thanks, Tom.
Thank you.
Good night, everybody.
Good night.
This is Kirk Carr, on the record. Thank you for watching.